Hello, this is Ben Bangs from Taylor Wessing. Let me welcome you to our webinar today. This is the first for 2015, so a slightly belated Happy New Year. Today's webinar is part of our regular webinar program where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous topics that we've been broadcasting since 2012. And these include looking at issues such as data transfers, the data protection regulation, development in the APAC region. We're also looking at some more topical and developing issues such as cookies and OBA, mobile apps, bring your own device, wearable technology, big data, and also more recently looking at electronic marketing. A full list and recordings of all those webinars are available if you missed them and if you still wish to engage with us on those particular topics. Today, we will be taking a look at the topic of managing data and cyber security risks. For those of you who are new to Taylor Wessing or new to our webinar program, welcome to you. As you will see from the slide, Taylor Wessing is a leading international law firm. We act for a range of clients in local and international markets, providing a full-service law firm offering. And we do that from our office footprint, which spans across Northern, Central and Eastern Europe, the Middle East and Asia. And as we announced more recently, we have 2 representative offices in the United States, in New York and on the West Coast in Palo Alto. And we've listed more details about the firm on the slide deck, which you'll see progressing in front of you. Today's webinar is brought to you by our international data protection practice. Our global team advises on all aspects of data protection and information law, and we do so from our office footprint, as I've just described to you. And that's driven as a global 20-partner data privacy team, and it's also complemented by our international network of data privacy law specialists, so we can be a one-stop shop for your multi-jurisdictional data privacy needs. At Taylor Wessing, we have a microsite specifically geared for all things data protection and data privacy, and that's our global data hub. From this site, you'll be able to access news, weekly updates, and also if you sign up and register, you'll receive a monthly mail shot of updates and also invitations to events, conferences, and to the webinar events, such as the webinar that we're broadcasting today. You'll also be able to access topical issues where we regularly look at issues that are raising concerns or challenges, access to webinars and events, and also recordings that I've mentioned, which are part of our virtual learning bank of webinars, and they're all fully accessible from the Global Data Hub. You can also access our more international information, which is there in the form of risk maps, and also country pages, and there's a growing number of country pages where we provide you with our views and an at-a-glance view of data protection law and developments around the world. So my name is Ben Bange. I'm head of the UK Data Protection Practice, and I'm based here in London. I'm delighted to be presenting the webinar today alongside several members of our data protection group. So today's presentation will also be provided to you by Susie Wakefield, who is in particular a part of our cyber breach team. It'll also be provided by Lucy Lyons and Coraline Rahani-Arani, who will be presenting on different aspects of what we're covering today. So what are we going to cover for you today? Well, first of all, I'm going to walk you through data protection and data breaches as a topic. So starting from, I guess, square number 1 in terms of what the requirements are around data protection and data security, and some issues you ought to be aware of as far as handling data breaches are concerned. We'll also be then handing over to the rest of the presentation team to look at some of the top tips for managing cyber security risks, looking at some issues around cyber insurance, and Susie will be covering that in particular, and then looking at some other developments in this particular area. For example, the Network Information Security Directive, which Coraline will be covering towards the end of the presentation today. I'll then just be wrapping up on a few more issues before we go to our usual polling questions at the end. And just to add a note, in addition to the introduction that you heard about the polling questions are there because we have a lot of requests and feedback that they're an important feature in our webinars. They allow the attendees to appreciate and understand the views on particular questions as expressed by the other attendees. So it allows you to understand what other organisations are going through and thinking about those specific polling questions. It is all anonymised, so we share the results, and we will share that a few minutes after the polling closes, so within the webinar today. And it allows you to have that aggregated view on those particular questions. So today's questions will all be focused around breaches and managing breaches and how that prevails in your particular organisation. I should also add, just before I start with my particular section, that we have covered data and cyber risks in previous webinars. We've had 2 full webinars on this topic, and those webinars start from scratch and go through this topic in a lot of detail. Much of what is covered in those webinars is still very relevant and very up to date, so I'd encourage you to look back at those webinars and tune into those if you want more grounding in this particular area. What we're going to do today is just recap slightly and build on top of what we've already covered before. So if you're looking for more in-depth knowledge, that's all completely available for you to look at your convenience through the Global Data Hub. So, to get moving with the substantive part of the presentation today, as far as data protection and data breaches are concerned, there is very clearly a legal landscape to be observed. This is not something that exists in some form of legal vacuum. We often refer to data security and data breaches and data protection as something that is relevant to the United Kingdom, but it is not just a UK issue. As we've covered in previous webinars and as we've mentioned before, data protection in Europe is something that is European-wide. It is a law that we have in the UK that emanates from the EU Directive. And it is Article 17 of the EU Data Protection Directive 9546 that lays down the broad requirements to keep data secure. And the requirements of Article 17 are implemented and reproduced in the UK data protection legislation, and also you will see that reflected across other implementing data protection laws across Europe. In the UK, we often refer to that as the 7th data protection principle. There are also other laws around data protection and privacy, for example, the Privacy in Electronic Communications regulations that also touch and have something to say as far as data protection and data security obligations are concerned. And there are other layers that build on top of that, for example, the Regulation of Investigatory Powers Act, laws on interception and security in that regard, as well as industry layers that build on top of data security obligations, some of which I will touch on today, and we have looked at in a lot of detail in previous sessions. So I've mentioned Article 17 and the 7th Data Protection Principle. What is the scope of both of these requirements? Now, they are essentially the same requirements. And to assess the scope of the 7th principle, we need to look further at the language of the 7th principle. Now, there's a lot of key definitions from data privacy law, from the Data Protection Act and from the Directive that are specifically mentioned within the 7th Data Protection Principle. And if you read the language says that organizations or data controllers have to take measures to guard against unauthorized processing of personal data, unlawful processing of data, and also accidental loss, destruction, or damage to personal data. And the measures that are required are appropriate technical and organizational measures. So it starts to shape some of the risks that the directive and that the law requires you to look at. Now, the language that is used within the 7th principle in Article 17, as I said, uses some of the key definitions that you'll find under the Data Protection Act, such as personal data and processing. As we covered before, the definition of processing is very, very wide. It covers pretty much all operations you will find that impact on personal data, whether it's holding, collecting, processing, or otherwise conducting any other form of processing or transactional activity or sets of operations for the data. It's very, very widely interpreted indeed. And also, if we're talking about personal data, that's data that relates to an individual. So it's pretty much any data that you will find in many organizations, particularly data relating to, for example, consumers or customers or clients where those corporate clients are actually named individuals, data within the HR environment, and so on and so forth. So you can soon see how actually the principle itself is quite far-reaching, given the definitions involved and given the wide-ranging risks that you're asked to look at. And also, if you're to look at further guidance that you've seen issued from certain regulators, and if we just use as one particular point only, the Information Commissioner Office in the UK refers to data security obligations under the seventh principle applying not just to discrete operations within a business, but to the whole operation and the whole life cycle within an organization that touches on data. So if you are an organization that collects data, then subjects that to further processing or inputs into systems and processes. There is analysis conducted if that data is outsourced or offshored or input into a cloud environment. The whole life cycle will be subject to not only the data protection legislation, but also this fundamental seventh principle. There is also a clear link between the seventh principle and other aspects of the data protection principles. So, for example, some of the other data protection principles talk about not collecting more data than you actually need. In other words, data minimization. So, if you were to proceed on the basis of data minimization, then arguably you're also helping yourself as far as your obligations towards data security are concerned. Because if you minimize the number of data, then arguably you minimize the amount of security exposure around the data. There are also principles around data retention. In other words, not keeping data for longer than is necessary for the purposes for which that data was obtained. So in other words, once you no longer need it for those purposes, you should really be getting rid of it. You should be deleting it. Now the process of deleting it is also subject to the seventh principle. But you're beginning hopefully to get the idea of all these other housekeeping principles around data collection, which are fundamental data protection obligations, all feed into this requirement around data minimization, not collecting more than you need to, and also once you've got it, then being fully aware that you have an obligation to keep it secure. A moment ago I referred to the language of Principle 7, which refers to appropriate technical and organizational measures. But what exactly does appropriate mean, and is it defined within the legislation? And unfortunately, appropriate as a term is not defined within the legislation, but there is further guidance, in particular within Schedule 1 of the Data Protection Act, which gives a bit more flesh around how that should be approached. So you'll find that the Data Protection Act, in particular Schedule 1, goes on to say that having regard to the state of technological development and the cost of implementing any measures, the measures must ensure a level of security that's appropriate to, firstly, the harm that might result from such unauthorized or unlawful processing or accidental loss, destruction, damage, as I mentioned in the seventh principle. And also, second point is it has to be appropriate to the nature of the data to be protected. So what does this all mean? In a nutshell, this means that a data controller, the organization that is bound to comply with the obligations in the seventh principle, has to carry out a risk assessment. And a risk assessment to establish what are the appropriate measures to counter any of the security or the risks to that data as the seventh principle sets out. So you need to carry out the risk assessment to then see what the consequences might be, in other words, the harm that might arise, if some of those risks were to materialize, for example, loss or unlawful or unauthorized processing, and then to calculate and implement the measures to minimize those risks actually materializing. And we've seen more advancement of this risk-based approach on other aspects of data protection best practice. And some aspects of this we've seen reflected in the forthcoming, or the proposals for the forthcoming data protection regulation. So, for example, when you're designing a system from the outset, privacy by design should require you to look at the different risk elements that are applicable to whatever the system is that you're designing, and then making sure that you've countered those specific risks by implementing technical and organization measures that are appropriate to mitigating or minimizing of those particular risks. When you're going through a process of change or reviewing existing processes or systems, then you should be conducting a privacy impact assessment. Again, going through the same motions of looking at the risk assessment approach, documenting that decision-making process around it, and also the controls that you have in place to make sure that you comply with the seventh principle and minimize those particular risks occurring. Hopefully, so far, what you're getting from what I'm saying is that there is no one-size-fits-all here. It depends entirely on the circumstances, the type of organization that you are, the data, and the type of data that flows through, and also then to be looking at the level of security that's appropriate to those risks for that specific processing element. There is further guidance that talks, for example, about other considerations which may well be relevant as to when you're considering what is appropriate. For example, when we're looking at the consequences, due regard can be paid to the state of technological development. In other words, the security measures that you adopt can have regard to the state of technological development and the availability and the sophistication or the lack of, as far as the controls and technological measures that are available in the marketplace. In other words, there is no specific requirements within the legislation to gold plate, to go out to the marketplace and, for example, buy the best technical controls that you can potentially buy. However, that might be the requirement once you've done your assessment and realize that actually the processing, the type of data, and the nature of the risks are such that you have to aim quite high as far as the technological development standards are concerned. So I've mentioned technical and organization measures quite often so far, and what do we actually mean by that? Now, some of this is actually very, very obvious. Some of this becomes more and more sophisticated and actually broadens away from what we as lawyers would be able to advise on. But we work quite closely with specialist vendors who can help take this particular implementation measure forward. There are the very obvious measures such as, for example, having firewalls or perimeter security technology to protect your systems and your databases and so on and so forth. There are the more obvious examples such as antivirus or threat detection software and having that type of technology available, or encryption that's applied to mobile devices, for example. The, again, more obvious examples of organizational measures will look at, for example, how you go about implementing the rollout of threat detection software, antivirus software, and the patches. So you begin to see the picture of not only technical measures, but organizational measures that really go hand in hand and allow the technical measures to really have some life and meaningful effect. Organizational measures will go much further and also look at, for example, how you influence, nudge, and manage human behavior. In other words, the reliability of staff, looking at the internal threat, and how you go about taking that further to educate and train employees and staff who have access to and are otherwise interested with data as part of their daily duties. How do you begin to pull all of this together? Well, this would all begin to dovetail together at a very high level, at least in some form of data or information security policy. That would all inevitably be subject to some form of robust information security management system. And again, just to mention, we have covered a lot of these points in our previous webinar in much more detail, particularly around all the key aspects of information security policy to make sure that they are there to actually genuinely match the risks posed by the type of data, the type of information, whether that's personal data, whether it's intellectual property, or other asset classes within the data that you hold within your organization, and how those security policies actually come to life, work, are effective, and actually manage the data and the risks posed by that. The security policies have a clear role to play. Security policies also have a clear role to play as far as managing things when they go wrong. So if you actually have a breach incident, or if the worst case scenario actually hits, then how do you actually deal with the breach incident? So that's something that should also be built into your information security management system, whether that's separate to your information security policy or an integral part of the guidelines around it. But surviving a breach should be something that is quite fundamental to that operational process. Surviving a breach involves some fundamental elements, and again, we've explored these in much more detail, so I'll just gloss over them at this stage. You need to be looking at how you contain a breach when it arises. And again, an incident plan should be well tested, rehearsed, to make sure that actually it can live up to some of the more serious and more predictable threats that might actually materialize against your information estate. But when they do happen, containment is a fundamental part of this. So investigating the incident is crucial. So deciding who should lead it, who will be the team, who will be in it, whether they have appropriate resources to get the job done, are all fundamental components of how you would actually survive a breach and how you would go about certainly the first 48 hours of a breach response plan. How you go about containment in terms of who should know about the incident is just as important as making sure you address containment from who should not know about the incident. So the internal management of the investigation is absolutely fundamental. It's fundamental for all sorts of reasons. One of those fundamental reasons is how you manage PR around a breach incident. So taking action is also quite important, and sometimes that's absolutely crucial, particularly in the first 48 hours. So making sure the appropriate resources are there is just completely fundamental. And we find this so often a point that is lacking when we are called by clients to actually help coach them through a breach incident. For example, finding someone that's got the authority to actually close down a network or to actually plug a gap that's there in the network to prevent further leakage of information. All those sorts of responsibilities and roles and authority points should be ironed out and rehearsed and tested and stress tested, ideally before an incident actually arises. And this is a stage where it's actually quite important to look at your recovery plan in terms of what can be done to limit the damage. Is this something you can actually control? Do you tell the police? Can you seek some form of injunctive or civil remedy around this? And as you begin to move forward, you'll see what the assessment of the risk is. You'll begin to understand what type of data is involved and what's happened to it. Is it sensitive data? Is it lost? Is it stolen? Is it damaged? Was it encrypted? Was it backed up? What does this mean for continuity? How many people are affected by the breach? What sort of volume are we talking about? And more importantly, linking back to the point that I mentioned earlier, and what sort of harm could be caused to those individuals, and making that assessment, and ideally having some form of idea before a breach arises as to what type of harm could arise in certain scenarios, given that you will already have an idea of what sort of data you have within your organization. That may lead you on to take another courses of action, such as notification of the breach, which may or may not be required depending on the legal obligation that is applicable to your organization. And that might vary if your operations or the nature of the breach is multi-jurisdictional, in which case you'll need to pay close attention and assess whether or not, given the different jurisdictions involved, you might be subject to different breach notification laws. In the UK, for example, there are mandatory reporting requirements, but only for certain sectors and certain parts of industry. As a general point, there is no mandatory reporting requirement in the UK at the moment. However, there is a best practice requirement to report breaches to the ICO, so the regulator does expect that you will report it. Now, there is a formula on that, which is assessed on volume of the data that's been exposed to the breach, and also the harm that might arise. So again, the assessment of the breach is going to be fundamental towards working out what your notification requirements are, and also notification in terms of, do you need to notify the individuals involved, and how do you do that? And in some cases, you might find that, for example, social media has already done it for you, in which case, how do you manage the messaging beyond that point? And then finally, stating the obvious, but again, so many organizations miss this point, learn the lessons from what's actually happened. So evaluate the effectiveness of the response to make changes to your data breach strategy to make sure, in effect, you don't suffer from the same breach incident again. So that's just a quick overview of what's happening under the current law. Of course, a lot of this is due to change, and we've seen lots of movement on the data protection regulation, which was unveiled some 3 years ago now and is still yet to be settled in its final form. It's still quite hotly debated, and one of those hotly debated areas is the issue around breach notification and where that is actually going. Now, the direction of travel, and we do have quite a detailed paper on this that we've just issued on the Global Data Hub, so please do read that at your convenience to give you a more in-depth update. But the direction of travel there is we are seeing a somewhat watering down of some of the obligations that we've seen first published some 3 years ago. However, we don't yet know whether or not the proposals and the changes to the proposals, which so far are all simply positions adopted by the different chambers across the European Commission and Parliament and Council, and we do not know yet whether actually any of their proposed changes and their proposed redrafting will be adopted in any form whatsoever. That is still quite hotly up for debate, and we still need to wait for the next official draft of the regulation, see whether the lobbying and the discussion around, in particular, data security breach reporting requirements will become more realistic. And we're hoping, and there seems to be a direction of travel towards those requirements being more risk-based as opposed to prescriptive, and therefore, as they are in their current form, somewhat challenging from a practical perspective to address. So again, if you want to see that in more detail, please do have a look on the Global Data Hub where we cover that for you. So I will now hand over to so I'm now going to hand over to Lucy Lyons to talk us through some of the top tips for managing cybersecurity risk.
Hi there. Considering that cybersecurity has been so much in the press lately, not only in the last year and through such hacks as the Target credit card hack and more recently the Sony hack, can expect that cybersecurity risk is going to be high on board meeting agendas in the coming year. The government recently this month published their Cyber Governance Health Check for FTSE 350 companies, which is a non-technical governance questionnaire as a tracker report to benchmark the progress of cyber risk. And 88% of companies now include cyber risk on their risk register, so we can see that it is being picked up from companies in general. Whilst the security measures taken will differ depending on the size and nature of your business, every company, whichever the size, should be implementing relevant procedures. And most recently, we saw the Department for Business Innovation and Skills launch the Cyber Essentials Scheme in 2014. This scheme was based on 5 basic qualifications of the 10 steps to cybersecurity, which was first launched in 2012 with this along with GCHQ as well, and has recently been relaunched as of last Friday. The relaunch provides further detail about each of these 10 steps, setting out a summary of each step, some risks to look out for, and then how to manage such risks. And the government health check on those 350 companies has detailed that 58% of companies that were involved in the questionnaire now assess themselves against those steps. Along with the government health check and relaunch of the 10 steps program, GCHQ have also produced a common cyber attacks report with the relaunch to help companies understand where the threat might come from and where vulnerabilities might be prevalent. Although the useful stats from the government health check suggest that 58% of companies are assessing themselves against the 10 steps, Robert Hannigan, the GCHQ director, recently said that we continue to see real threats to the UK on a daily basis, and the scale and rate of these attacks shows little sign of abating. So it is something to pay attention to, even though it seems perhaps simple at times. The GCHQ report on these common cyber attacks sets out who these attacks might come from, ranging from cyber criminals to hacktivists to employees, and then where these kind of vulnerabilities might lie in your business. For example, through flaws that are unintended, through certain features of your network or software used that are unintended but misused by attacks, or by common user error. There are then the report then sets out some stages of the attack, so whereby an attacker might survey what information is publicly available, find a vulnerability in the system, exploit that vulnerability, and then ensure maximum effect from that exploitation pinpointed. I'm going to run through the top points of the Cyber Essentials schemes now, which are those 5 basic themes from the 10 steps to implement. The first one, which is a common theme throughout all the 10 steps and throughout the Cyber Essentials schemes, is the use of a strong password, which might sound very familiar, but is something that can act as your first line of defense. And the best way to ensure that this is a policy adopted is to set it out in an enforced password policy the scheme suggests, and not only avoiding easily guessed passwords, but ensuring that accounts are locked after multiple failed attempts and additional authentication measures are used for access. The scheme also mentions that it's important to think about public information which may be available, even if not easily guessed, that could lead to your password being exploited by hackers. The first theme on the Cyber Essentials scheme is boundary firewalls and internet gateways. Boundary firewalls, internet gateways, or comparable network mechanisms should be in place to protect systems, applications, information, and devices against unauthorized access and exposure to the internet. Without these in place, systems are at risk from being easily accessed and leaving information exposed and at the risk of deletion. A boundary firewall acts as a defense by regulating inbound and outbound network traffic, blocking those common cyber threats that are created easily from widely and freely available tools on the internet. It can help to maintain a list of those websites that can cause problems and can block and unsecure unnecessary services. The second theme is secure configuration, which is, as mentioned by Vin, to design to limit the functionality of some devices so that they only have the use for what they are strictly needed for. Any device that connects to a network should be configured in this way to help reduce characteristic vulnerabilities of some devices. Those default settings and applications on many devices can serve as a route for cyber attackers to gain easy access to the information on these network devices. And the Cyber Essentials scheme suggests that when installing network devices, some basic controls should be employed, such as any unnecessary user accounts should be deleted, Redundant software should be removed. Software settings such as auto run should also be disabled to prevent software settings from being easily accessed by hackers, and a personal firewall should be enabled on some computers. Also important to implement access control in your regulation of your own security. This is enforcing the principle of least privilege, so that user accounts allow for the minimum level of access required for applications and devices and networks. Users that require special privileges to manage controls must be authorized individuals. If these accounts were to be exposed, there is more information at risk, and if exposed, the effects can be far-reaching and can rapidly accelerate. The default position should be that the lowest level of privilege is therefore applied to user accounts. Malware protection should also be used against not only computers, but those desktop PCs, laptops, servers, and other devices such as tablets and smartphones, which are used by computers. It might seem an obvious protection, but it will help ensure greater potential from those cyber attacks. The protection software should also be kept up to date and configured automatically so that it scans files once accessed and performs regular general scans. It can also be used with the firewalls set up to block access to malicious websites. The last thing of the Cyber Essentials Scheme's top 5 recommendations is patch management. Devices such as computers or other devices connected to a network are at risk of being exposed to weaknesses contained in that software which those devices run. Once these flaws are exposed, which are often discovered on a daily basis, they quickly can be exploited for misuse. Software producers will often monitor these and release software updates known as patches. And it's important to formalize the patch management process so that updates can be monitored effectively and installed efficiently, forming a strategy detailing the type of patches that should be applied to each software or system and at what time. The scheme recommends that updates to software should be installed promptly or at latest within 30 days of release for security patches. In addition, any software used should be licensed and supported by the supplier or vendor of that software to ensure that relevant security patches are provided, and software that is no longer supported should be removed from those network-connected devices. It's important to note that if an organization has chosen not to implement a certain control as set out by the scheme due to reasonable business grounds, or that it's not practical or possible to install, alternative controls should be put in place, and this should be further detailed. As well as providing guidelines set out in the 5 themes, the scheme also allows, through the assurance framework, the certification of organizations of either the Cyber Essentials Scheme or the Cyber Essentials Plus Scheme. To date, 200 companies have the Cyber Essentials badge, and so far 150 more are in process. On Friday, it was also announced that National Grid, GlaxoSmithKline, Standard Chartered Bank, Aberdeen Asset Management, and Babcock International would be pursuing the UK's Cyber Essentials Scheme. So there is uptake on this. In the GCHQ report on common cyber threats, GCHQ also recommended that boards should take into consideration the wider 10 steps to ensure cyber security, as well as these 5 mentioned in the Cyber Essentials Scheme. And it's therefore important to be aware of the suite of 10 steps that are available. So I'll just run through these other ones now. The other themes are information risk management, so as to ensure that the same attention is given to cyber security as you would give to legal, regulatory, financial, or operational risks, and embed the regime so that it's regularly reviewed. User education and awareness is important so that all users understand how operations can lead to vulnerabilities, and personal security responsibility is adequately understood. Incident management should be managed in a formal process and policy to ensure business continuity, resilience, customer and shareholder confidence, and reduce the financial and PR impact. Also important to increase monitoring to ensure that cybersecurity risks are detected more readily and a business is able to react to these more quickly. Also, the 10 steps of cybersecurity point out the possible risks posed through removable media controls of home and mobile working, and it's important to balance those risks and your controls surrounding certain policies. The advice sheets I mentioned earlier further set out these 10 steps of cybersecurity, as well as offering some examples of risks, also set out how to manage these. Also briefly discussed the Information Commissioner's view on the theme, who recently said that it enables businesses to demonstrate that they are taking action to control the risk and can particularly help perhaps against the 7th Data Protection Principle as well. Information Commissioner also noted that the important role that cybersecurity plays in protecting personal data, especially as the challenge to safeguard personal data is made increasingly difficult due to more sophisticated cyber threats, and as businesses often fail to address the basic security principles. This was another aspect that was picked up in the relaunch of the 10 cybersecurity steps. That was these openly available tools to cyber attackers are effective because basic security steps aren't taken by businesses, and the 10 steps can help to ensure that this will be more effective. In setting out how to approach information security, the Information Commissioner has suggested that businesses should adopt a risk-based approach in making decisions about levels of security needed. In general, businesses should consider, in their approach to information security, that security is constructed to be appropriate to the type of personal data collected. It is clear who in the organisation is responsible for information security. Physical and technical security should be suitable for the nature of business and backup, and security policies should be in place, as well as well-trained staff to ensure security is managed appropriately. A breach incident policy should also be put in place to ensure that any breach can be dealt with efficiently. The FTSE 350 government cyber governance health check, despite showing that there was more uptake in boards paying attention to cyber risks, did relay that only 5% of main boards regularly and thoroughly reviewed their key information and data assets. Given the amount of attention that cybersecurity has got in the press recently and the simple steps that businesses can take to ensure this, cybersecurity is increasingly being handled at board level, and all organisations should consider the advice issued by the Government and Information Commissioner on this subject.
Thank you, Lucy. So in the remaining minutes, we'll just begin to wrap up on the final topics that we've got left, handing over next to Susie to talk about the cyber insurance market.
Thanks, Ben. I'm conscious of time, so I'm going to give a fairly high-level overview of some of the current issues in the cyber insurance market. Cyber insurance is a very hot topic now in the world of insurance. The cyber insurance and reinsurance market is still in its relative infancy, more so in Europe than in the US. And as it continues to develop, both insurers and insurers face quite a bit of uncertainty when it comes to writing and buying cyber risk products. Essentially, there's a real need for more clarity and knowledge in the market, which is bound to take some time to acquire. But most businesses and insurers are certainly by now well aware that the risk of cyber attacks are ever present and that the costs to business can potentially be extremely high. We've already mentioned, and you will have certainly heard of the most recent high-profile cyber attack, the Sony Pictures hack. But cyber attacks can be commonplace at a very wide range of organisations. And by way of example, the Bank of England recently said that it faces around 8 incidents per week. 81% of large organisations and 60% of small businesses suffered a security breach in 2013, and the average cost for small businesses were between £65,000 and then £115,000, while for the larger businesses the range was between £600,000 and £1.15 million. Despite those risks and the potential significant costs, many SMEs and even some of the larger organisations do resist improving their cybersecurity, mitigating the risks of breaches until there's a pressing commercial need to do so. So from a business's perspective, when considering cyber insurance, they tend to ask questions like, is it worth it? How much will it cost? When do I need to arrange it? As well as questions and uncertainty as to whether they already have certain elements of cyber coverage provided within their current insurance program. The problem is that those questions can't be answered simply by looking at a policy, and purchasing cyber insurance needs to form part of a comprehensive cyber security plan, including an assessment of the risks the business faces, and understanding and implementing safeguards to mitigate those risks. Although putting in place a cybersecurity plan may be difficult, it's certainly a sensible first step to understanding whether purchasing cyber insurance is worth it and what limits of cover might be acceptable. From the insurer's perspective, the real difficulty lies in fully understanding the risks and costs they are underwriting. While a number of insurers are already establishing themselves in the market with dedicated and standalone cyber policies, the market is still developing, and the types of risks and the types of policies out there are certainly varied. And insurers really face their biggest difficulty in just accurately evaluating the cyber risks, and with a lack of loss data available in deciding the appropriate limits for the risks. So when it comes to selling cyber products to businesses, the demand for cyber products has certainly not yet seen a boom. The price and lack of knowledge remain significant barriers to businesses appreciating the need for cyber coverage. And businesses may find it difficult to understand why they should pay what might appear to be relatively high premiums for cyber cover when they may be paying significantly less premium for more established policies like D&O or property damage, which cover up to the same limits. As I've mentioned, given the nature of the market, there can be real differences between the different policies and the coverage they offer, and different businesses face different risks, and so it just isn't possible for businesses to make a sensible comparison between policies based on price alone. But they need to review the policy wordings carefully and consider the policy, consider whether a particular policy is effective for its own business model. Having said that, as knowledge in the market increases and the market develops, businesses are certainly likely to be more motivated to purchase cyber coverage. And one of the key selling points of the policies is likely not, in fact, to be the limits of coverage, but it's rather the additional breach response benefits that are provided to the insured, and how effectively an insurer deals with a cyber breach, and the network of breach response experts and services that the insurer might make available to its insurers under the policy is certainly key. A breach requires the involvement of a number of different experts, including lawyers, IT forensics, credit and data monitoring firms, specialist PR firms, communications and notifications firms. So while many businesses will be familiar with working with their regular advisors, they may find the number of experts and the coordination needed to respond to the breach difficult, and managing those work streams to be quite daunting. Just to wrap up, there is certainly more awareness and understanding of cyber risks, and an upward trend in both the number of insurers offering cyber products and the number of businesses seeking insurance protection. What remains to be seen is just how rapidly the trend will grow, and whether in the near future cyber coverage will become a standard to businesses as D&O, property or other liability policies. For those of you who are interested, we have just finalised a cyber risk publication which deals with cyber liability and breach response issues. So do look out for that, and let us know if you'd like us to send you a copy.
Thank you very much, Susie. So just for the final session on the Network Information Security Directive, we'll now hand over to Coralie.
Thanks, Vin. I'm also conscious of time, so I'll try to go through this quickly. I'm covering Europe's response to the issue of cybersecurity, which is the draft Network Information Security Directive. It is close to finalisation, and the Parliament, the Council and the European Commission are currently battling out the final wording. It is expected very soon. In fact, we were promised it at the end of last year, but it wasn't released, and we will certainly keep an eye out on it for when it comes out, as everybody's interested. But just in short, I think I should give a brief background on what it does. The directive is a rather bold initiative, and it is the first attempt to legislate in the cybersecurity arena. It is different to the approach taken by other countries, such as the United States, who have opted for an industry-led and voluntary approach. In short, the directive adopts a multi-layered approach. It aims to place a number of obligations on various stakeholders across the industry. Firstly, it requires member states to establish a national network information security strategy and establish regulatory measures to achieve network security. It requires member states to establish a competent authority, the NCA, to monitor the application of the directive in their territory and member states, and for the member states to establish a computer emergency response team that handles incidents. It also requires the member states, national competent authorities and the European Commission to form a cooperation network. Interestingly, and further, it also requires market operators, in quotes, that provide critical infrastructure, the disruption or destruction of which would have a significant impact on a member state, to comply with the mandatory security breach and incident notification requirement. These market operators are targeted across a number of industries and include operators in the energy, telecoms, banking, health, and transport and financial services sectors. It's worth noting that telecoms operators already, for example, in the UK, are subject to similar requirements under the Comms Act that are actually derived from the EU Framework Directive, but certainly for other industries this is relatively novel, and I think it will impose a number of significant requirements on them, especially as they're not used to, I suppose, complying with requirements in terms of network security. But it certainly aims for a more targeted and more coordinated approach. I then want to just touch briefly on whether it does enough. And whilst the introduction of the directive as an unprecedented measure to legislate against cyber threats does introduce a more coordinated approach, it doesn't, in many people's opinions, it doesn't quite go far enough, and it also leaves a number of gaps and inconsistencies. I think the first big inconsistency and the first gap is really the fact that the directive in its current form hasn't really addressed how the coordinated approach is to come about. So, for example, it doesn't really set out guidelines for how the competent authority will ensure a consistent application of the directive across member states. Or more importantly, it doesn't really set out how the member states should resolve conflicts when it comes to addressing cybersecurity. And as we have seen in the attitudes of many countries like France and Germany, they are vastly sort of divergent to the way, for example, the UK thinks about it. The former prefers a more regulated approach and the latter prefers an industry-led approach. So if it comes to sort of type of disagreement in attacking a cyber threat, the fact that the directive doesn't really set out how people will resolve their disagreement, I think will actually result in sort of a significant impact, especially from a timing perspective, to tackle the problem. The second problem is that there is current disagreement between the European institutions over whether member states should be allowed to select the operators to whom the new rules should apply. The text of the directive put forward by the Council by the Council allows the member states to select the operators within the industries to whom the new rules apply. This is different to the approach taken by the Parliament, which is basically all operators would become subject to the directive, and obviously the latter is actually a much more coordinated approach, and it would mean that everybody would become subject to it. But the third and the most important unresolved issue is the scope of the directive itself. The original draft proposed by the Commission included key internet enablers as being subject to the directive. Those are the likes of e-commerce providers and platforms, social networks, search engines, cloud services, and app providers. But this category was later taken out by the European Parliament, and the application of the obligations was limited to operators of critical infrastructures that are essential for the maintenance of vital economic and social activities. The Parliament, the EU executive, and countries such as France and Germany have been in favour of keeping these operators in, whereas the Council, as well as the internet industry itself, for obvious reasons, are strong objectors, arguing that such obligations would create a significant administrative and financial burden, as well as result in duplicative and unnecessary reporting by both the infrastructure and services providers. The Council's final decision in respect of this issue will likely have a significant impact on the effectiveness of the directive. So I think in terms of what's next, we are still expecting the final text and final draft of the directive. And I think because there's so much disagreement on the issue of the exact scope of the directive, it'll either be very watered down and not really set out who it should apply to, and in a way we won't really get a proper response, or it will set out that it will apply to everyone, in which case we'll get a much more coordinated approach. But if the latter happens, there will be a number of requirements that people that are not necessarily used to ensuring network security, such industries such as people in the energy sector and financial services sector, will need to effectively comply with these requirements. And really, it's a bit of a watch this space. We will keep an eye out for the final text, and when it comes out, we will release an update on that.
Thank you very much, Corinne. So that really brings us to the very tail end of our webinar today. And as I mentioned at the beginning, we've already covered this session and this subject twice before today. And somehow I think we'll be covering it again, because there's certainly a growing space, growing area, and there is much more to develop around the area of data and cybersecurity and breaches. We are seeing increased development in this area in, for example, Asia, where there are new laws, all of which have something to say about data security. We're also witnessing examples of data breaches in Korea, in Singapore. We're seeing enforcement action from regulators in those countries where we are seeing new data protection laws, action from regulators outside of the data protection space as well. For example, the Monetary Authority of Singapore has taken action and enforcement activity in the banking sector and the financial sector for data breaches. So a lot is happening, and in different sectors, in different countries, and also the issues around corporate reputation management and PR, and corporate governance in terms of responsibility for listed companies and so on, will continue to have something to say and help shape the debate around managing and dealing with data and cybersecurity breaches. So we will continue to revisit this topic as and when substantive developments change. Just before we close, and there's still, I know we've reached our allotted hour, but there's still a significant number of you that are still with us. So we wanted to just try and feed back to you your responses to the polling question. So I'd be grateful if you could click away your answers to the following questions. And there's only 4, so please do fire away your answers to, firstly, whether or not you've experienced a data or cyber breach in the last 12 months, whether it's small, large, medium, or something that's hit the headlines, or whether you've kept it out the headlines. It would be interesting to know how many of our attendees and their organisations have actually experienced a breach issue. And for those who have, what was the cause of it? And it's a fairly rough and ready 3-way categorisation, but we tend to find most of the breaches that we deal with tend to fall into the categories of either being due to an internal threat, a rogue employee, for example, an external threat, or some form of systems glitch that has led to it. And as far as managing breach incidents are concerned, do you have a robust and tested data breach plan in place? So give us an idea, yes or no. We've talked a lot about measures, and risk assessments, and appropriate controls, and the cyber essentials, and what's expected. So again, it'd be interesting to know the state of play amongst the organisations that are on our webinar today. We do have, I think, a fair representation of local UK, European and international organisations on the webinar today, so I think it will give a good all-round representation. Finally, we mentioned cyber insurance as a risk mitigation point, and this is something that's becoming more and more available, certainly in the European market. So is this something you're considering in the next 12 months? Again, give us an indication so we could give you an idea of what we're seeing in that particular environment. And just as we're waiting for some of those results to come through, just to let you know that our next webinar will be on the 17th of March. where we plan to look at the issue of connected data, where we want to explore issues around the Internet of Things in particular, and also give you an update on wearables and big data, which we have already explored in the past, but clearly there is a relevance of those issues around the topic of the Internet of Things and connected data. That's what we plan to bring you on the 17th of March. Just as we're waiting for the polling results to come through, and I appreciate your patience on that, we have had some questions, some of which I can answer now whilst we're waiting for the polling results to come through. First question is from one of the attendees saying, not being a UK qualified, what is the difference between the UK Data Protection Act and the seventh principle that you mentioned? Which one is the implementation of the EU Directive? So just to clarify that point, at the top level we have the EU Directive on Data Protection 9546, came into force back in 1995. That's the European directive, and that's the European instruction to all member states to implement the local data protection law. In the UK, that was implemented through the 1998 Data Protection Act. The 1998 Data Protection Act has 8 data protection principles. That is the fundamental framework that is provided through the Data Protection Act. One of those principles, one of those 8 principles, the 7th Data Protection Principle, focuses on data security. So that hopefully clarifies how that all fits together. So we've got a couple more questions, and I will cover those as many of you are still on the line. But we've also got the answers to the polling questions that have come in. So let me give you some of the responses. And they're changing slightly as the results are still coming in, but let me give you the view. So the first question, have you experienced a data or cyber breach in the last 12 months? Almost a third of you say that you have experienced that, and 2/3 of you have not experienced it. So that'll give you an idea of what your fellow attendees and their organisations have experienced. And for the third of you who have experienced a data breach, what was the cause? And it seems to be that there's a fairly even split between internal and external threats, with a much lower proportion saying it was due to a systems glitch. In terms of managing and handling breach incidents and your readiness towards it, question 3, do you have a robust and tested data breach plan in place? 51% of you say that you have. And that's incredibly reassuring, because the last time we polled on this point, I believe that figure was in the region of 30%. There's only about a third from recollection. So now we've nudged that figure up to half. But clearly that still leaves half of you that haven't put in place a robust and tested data breach plan. Would you consider cyber insurance in the next 12 months? And again, that's pretty evenly split. Half of you would consider it, and half of you wouldn't. So I'm not sure what that quite tells us, but it certainly shows that there is active consideration and active preparation around data breaches, but still an awful long way to go for many organisations as well. I will just deal with 2 more questions, simply as, and I know we've timed out, there are quite a few still logged in. There's one question about the Cyber Essentials certification. And the question is that there's been some communication in the media that the government in the UK is requiring companies that it does business with to hold a Cyber Essentials certification. The question is, in practice, it does appear that the government departments actually require this. Is that a requirement, is the question. Now, we're not aware that it's actually a legal requirement for organisations to have a Cyber Essentials certification. But there are some interesting examples of how perhaps we're seeing some benchmarking against the Cyber Essentials certification taking place, given that it's one of the sort of new kids on the block as far as certification is concerned. In the past, when we've seen, for example, if we step back, say, 15 years, when we saw standard 7799, which is a BS and an ISO, dealing with information security management systems, when that first came in, we saw a lot of organisations saying that is our benchmark and we expect certification against it. And then when that morphed into 27001, we still saw organisations saying we're going to benchmark our partners and suppliers against certification along those lines. And then we saw perhaps a degree of maturity around benchmarking and perhaps more sophistication, which led to the differentiation between certification and accreditation on one hand, and a more mature assessment of security controls, which are perhaps based on an information security management system as set out in the 7799 or 27001, but perhaps not accredited to it. So, in other words, a more detailed and a much more sophisticated evaluation against the standards and not necessarily a certification. Whether or not the government goes in that direction in terms of its requirements and benchmarks, well, time will only tell, but that might give you some indication if historical accounts provide any indication of what we might see going forward. Another question that's come in is, with the increasing movement of data into the cloud, how do we draw the lines in terms of protection of that data and liability in particular if that data is exposed and leaked once it goes into a cloud-based environment? My view on this is there is a fundamental point under data protection law in Europe, and we see this reflected in many data protection laws around the world, and that is the data controller, the organization, or for example, the data collector in Singapore or in Asian data protection terms, always remains on the hook. It always faces a frontline liability and therefore is responsible for data security, even if it then outsources that data into other environments and to other processes. The obligations that flow under law are that the requirements to keep that data secure, many of which I talked about today, ought to flow onto all parties that handle that data on behalf of the data controller. And that's a fundamental requirement under the seventh principle as well. So contractual obligations, some of which are commercially desirable, but some of which are mandatory under the seventh principle in Article 17, are required to flow along with the data. But the fundamental reliability under the data protection law does not simply flow along with the data. That's something that has to be passed along as a responsibility under the contract. Interestingly, as we've mentioned, the General Data Protection Regulation, that formula around where the liability lines are drawn and who is responsible under the law is set to change under the General Data Protection Regulation. And that's something that we will visit as we get more clarity on those points. So I will end the webinar there. Thank you very much for staying with us. I know many of you have, even though we've gone beyond our allotted hour. Hope many of you can join us on our webinar on the 17th of March when we look at the topic of connected data. From the team here at Taylor Wessing, thank you very much and goodbye.
Thanks for using WebEx.